This session of Parliament will now resume and the meeting resumes. Point of order, Neil Findlay.
Thanks, Presiding Officer. I can fully understand why you suspended Parliament there, but this does set a precedent, I think. Everyone knows that debates, question time and all the rest of it is a follow-on. We're going to be discussing a very important piece of legislation that I think will be agreed consensually by the Parliament, and I would never seek to halt that. However, I have to question whether the same tolerance would be applied if, say, a member, an opposition member or whoever didn't turn up for a question, didn't turn up for their member's bill or a motion or a member's debate. So I really want to question whether this is going to be a consistent approach that the Chair, and I'm not having a go at you personally, I understand why this is done, whoever is in the Chair is going to take should members be elsewhere for whatever reason. Thanks.
Thank you for your point of order, Mr Findlay. And of course, can I say to the Chamber that the reason that I felt I had to suspend was because business couldn't carry on as it should have, because we had no one here who could move the motion that we are debating this afternoon. But can I say that this is not acceptable and should not have happened, and the business should indeed have followed on from the Cabinet Secretary's statement on the budget. Yes, point of order, Mr Findlay.
Follow up, just so that I'm clear in my own mind on that then. In normal circumstances, would that have meant that that business would have fell and we would have moved on to the next business? Is that how the standard? I personally don't know that, so it was just for my own information. Thanks.
There is a decision that can be taken by the presiding officer, Mr Findlay. The motion as put forward is of course proposed by Hamza Yousaf and seconded by Ash Denham, neither of whom were in the room, either in this chamber or on the Blue Jeans platform. Therefore, the motion could not be moved. Therefore, I took the decision not to abandon the business, as you say, but to suspend this meeting so that we could carry on with this very important business. So we shall now carry on with that very important business, and it is a debate on motion 23983 in the name of Hamza Yousaf on the Domestic Abuse Protection Scotland Bill at stage 1. And I would invite those who wish to speak in the debate to press the request to speak buttons, and I call on Hamza Yousaf to speak to and move the motion for up to 12 minutes, please, Cabinet Secretary.
Thank you, Presiding Officer, and can I begin by apologising to you, Presiding Officer, and to the entire Chamber. I was getting ready to log on before the end of Ms Forbes' statement and can only by a technical malfunction. I had been on the phone to our IT earlier on in the day to resolve the issue. I thought it was resolved, but clearly not. So forgive me, and I apologise to the Presiding Officer, of course, and also to all members in the Chamber and present. I am pleased to open this afternoon's stage 1 debate on the Domestic Abuse Protection Scotland Bill. This bill is an important additional piece of the Scottish Government's overall approach in improving how Scotland deals with the scourge of domestic abuse. Much progress has been made in recent years through, for example, the new offence of domestic abuse and increased support for those experiencing domestic abuse, all delivered through the prism of the Equally Safe strategy. But there's always more to do, and this bill is part of those necessary further steps. Presiding Officer, I intend to respond to a number of issues raised during the scrutiny process in my speech. But first, let me thank members of the Justice Committee, the clerking team, and all those who gave evidence on the bill that helped shape the comprehensive, very helpful stage 1 report produced very swiftly following completion of the oral evidence sessions. Before I address the specific points raised in the report, I think it is important I briefly set out what the bill actually does. So part 1 of the bill creates a new scheme of domestic abuse protection notices and also domestic abuse protection orders. The notices and orders will be used to protect people at risk from abusive behaviour by a partner or ex-partner where there is an immediate risk of abuse. The bill empowers senior police officers to be able to make a very short-term domestic abuse protection notice, which can remove a suspected perpetrator of domestic abuse from the home of the person at risk. It can also prohibit them from approaching or contacting the person at risk, as well as a limited number of other very specific conditions. These notices can be made prior to consideration by a court, and they're intended to allow for protection to be put in place immediately where police consider it to be necessary. The bill also contains a power for a court to make a domestic abuse protection order, which can have effect for up to 2 months initially and is capable of being extended for up to 3 months in total. The system of orders is designed to allow for judicial oversight very quickly following the imposition of a domestic abuse protection notice, as the police are required to apply to the court for an order within 1 court day of making a notice, and the court are required to hold a meeting in relation to the application by the following court day. This is an important procedural safeguard for protecting the rights of any person who is subject to a police notice. The police can also apply for an order without first making a notice in a case where they consider an order is required to protect the person at risk from harm, but that the level of urgency is not such by making a notice. These measures are intended to complement existing criminal or civil processes by providing a new means of protecting a person of risk. That is immediate, that does not require action on the part of the person at risk, and of course, crucially, is independent of any criminal investigation where there may not be a sufficiency of evidence to proceed with a criminal prosecution and unlock existing criminal court powers, such as special conditions or bail, or special conditions of bail, or indeed of remand. Presiding Officer, Part 2 of the bill makes provisions to enable social landlords to transfer their tenancy to a victim of domestic abuse. It does this by creating a new ground on which a social landlord can apply for a court order to end the tenancy of a perpetrator. This is with a view of transferring it to the victim of domestic abuse, or where the perpetrator and victim are joint tenants, end the perpetrator's interest in the tenancy. And this would allow the victim to remain in the family home as a sole tenant. Having the legal ability to end the perpetrator's tenancy in domestic abuse cases will allow social landlords, without requiring victim to commence this process themselves, they will be able to take a more proactive role in supporting and protecting victims of domestic abuse and support the victim to remain permanently in the family home. I suspect I am not the only MSP presiding officer to have seen a number of cases, unfortunately, where the victim of domestic abuse felt like their only option was to flee the family home and become homeless. That cannot be right, and this bill seeks to redress that issue. Presiding Officer, it is important to reflect on the core issues that the measures in this bill are seeking to address. At the moment, a person wishing to obtain protection from domestic abuse, particularly in relation to keeping a perpetrator away from the home, can only do so if the perpetrator enters the criminal justice system or if the victim themselves takes out a civil order against the perpetrator. The onus is currently on the victim in that case. We know that where a victim of domestic abuse is living with a perpetrator, it may be very difficult for them to take steps to address their long-term safety, particularly where this involves taking action in the civil courts to remove them from the home. As some of those who have given evidence to the committee noted, this can result in a victim of abuse having no alternative, as I've already said, to make themselves homeless to escape that abusive partner. The new scheme of protective notices and orders are therefore intended to fill a gap in that where someone is experiencing domestic abuse, they are more likely to lack the freedom of action to pursue a civil court process to remove a suspected perpetrator from a shared home. The measure will also provide the person at risk with short-term breathing space, which will enable them to consider what longer-term steps they may want to take to address their safety and the safety of their family, as well as their future housing options. The longer-term steps will depend on their particular circumstances, but could include pursuing other existing civil measures, such as an application to a civil court for an interdict or indeed for an exclusion order. Enabling social landlords to end a perpetrator's tenancy in domestic abuse cases also seeks to address the very real issue of why victims and their families, rather than the perpetrator, should have to leave their homes, their belongings, their community, all to seek some safety and sanctuary, while the perpetrator remains undisturbed in the family home. Presiding Officer, I welcome the committee's support for the general principles of the bill. However, I also acknowledge that there are a range of issues have been raised and aired during the committee's scrutiny, which are important to the eventual successful implementation of legislation. I heard from every single member of the Justice Committee, representing all different political parties, confirming the issue, of which I have no doubt, of course, that they all support greater protection for domestic abuse victims. But there was real concern about some of the operational impact of domestic abuse protection notices and orders and the interoperability of them with other civil remedies. So I hope to be able to address some of those key areas in the rest of my opening remarks. So there is most definitely a need, I think, for full and effective scrutiny of these operational matters. And I've discussed these matters, these issues that have been raised directly by the Justice Committee with me, with the Chief Constable of Police Scotland. I know the committee has also heard feedback, of course, from Police Scotland directly about some of those implementation challenges. I will instruct an implementation board led by the Scottish Government, which will bring together all the key agencies affected by the new legislation, including, of course, Police Scotland. While some of the operational issues raised during scrutiny will, of course, be for the implementation board to consider as guidance is prepared for the use of the legislation, there are also some policy matters that need to be addressed and discussed. The committee report discussed the threshold of the test before a notice or an order can be imposed. In discussions with Police Scotland, I can advise we are looking at whether the test of future harm required before a notice can be imposed should be set at significant harm, and we will keep Parliament updated as this consideration continues. Parliament will not be surprised that in my discussions with Scottish Women's Aid and other victims' organisations, they have real concern about increasing that evidential threshold. But I will continue those discussions both with Police Scotland and victim support organisations. Given the seriousness of removing a perpetrator from a home, it may be that the threshold should appropriately be set at a higher level. I'm pleased the committee supported the length of time that a notice can run and the length of time an order can run. There is a careful, I think, balancing act with these timescales to keep them as short-term protections while respecting the rights of the person who is subject to the notice of an order, bearing in mind that they have not been convicted of a crime. I consider the bill strikes that appropriate balance. The committee report also discusses the way in which views of children can help shape decision-making as to whether notices or orders should be imposed. There is a considerable challenge in balancing the fundamental policy intention of the bill to improve immediate protection for those at risk of domestic abuse, while ensuring the views of affected children are taken into account. The bill does provide that the welfare of children is a key factor for the court when deciding whether to impose an order if those children would be affected by such an order. And where the court is considering imposing an order with provisions that would relate directly to a child, then the bill emphasises that any views of that child of which the sheriff is aware should be taken into account. I can confirm we will consider carefully whether further provision is needed, which continues to ensure that the overarching policy intention of immediate protection for those at risk of domestic abuse can be delivered. Presiding Officer, in conclusion, I look forward to today's debate. I commit to considering all suggestions for how best the legislation itself can be improved, and importantly, how effective operationalisation of the new system of orders and notices can be delivered. If we can deliver on both these aims, that we can ensure there is new and improved protection available for those at risk of domestic abuse. Presiding Officer, I commend the general principles of the bill to the Parliament, and I move the motion in my name.
Thank you, Cabinet Secretary. Before I call Adam Tompkins, can I say, as most of the members speaking are remote, therefore there's no opportunity for interventions. If members contributing want slightly longer for their speech, a minute or more, don't mean to be obliged, then feel free to do so, as we have time in hand. I now call Adam Tompkins on behalf of the committee. Convener, please.
Thank you very much, Deputy Presiding Officer. This is a simple bill that raises quite complex problems, problems which the Justice Committee has not found easy. As we've just heard from the Cabinet Secretary, the bill does three things, each designed to sharpen the effectiveness of the tools we have to combat domestic abuse. And combat it we must. Every year, Police Scotland are called out to something in the region of 60,000 incidents of domestic abuse. That's 5,000 every month, nearly 1,200 every week. And each one of these consumes on average 9 hours of police time. The social costs are massive, to say nothing of the horrific impact on the victims of crime. Let me say a word about these three new tools that the bill provides for. The first is the Domestic Abuse Protection Notice, or DAPN. A Domestic Abuse Protection Notice enables the police to impose requirements on a person where the police have reasonable grounds to believe that the person is engaged in abusive behaviour. And such a notice is said to be an emergency measure. A breach of its conditions is a criminal offence, and its effects can be severe, forcing a person to leave their home and, if necessary, preventing them from approaching or contacting their family. The second tool, the Domestic Abuse Protection Order, or DAPO, is imposed not by the police but by a court of law. And wherever a DAPN is issued, the police must apply to the court for a Domestic Abuse Protection Order on the very first court day after the notice is issued, and the hearing must be held and concluded in court on that day. A DAPO may impose any condition on a person that may be imposed by a DAPN, but unlike the notice, the order may remain in force for up to 2 months, extendable to 3 months on a further application to the court. And breach of any condition imposed by a DAPO is a criminal offence. And again, it needs to be understood, Presiding Officer, that the effects of a DAPO on a person may be severe, excluding the person from their home and depriving them of contact with their family. The third tool relates to housing. The bill gives to social landlords a new power to evict a tenant where the tenant has engaged in abusive behaviour. And this new power will sit alongside other powers already contained in Scots law in, for example, the Matrimonial Homes Family Protection Act and the Housing Scotland Act. Presiding Officer, the Justice Committee took evidence on the Domestic Abuse Protection Bill in December and this month in January. As well as hearing from the Bill team and the Cabinet Secretary, we heard from stakeholders such as Scottish Women's Aid and the Scottish Women's Rights Centre, from the Law Society and from academics, from Police Scotland, and from housing experts such as the Chartered Institute of Housing and Homeless Action Scotland, as well as others. And I would like to thank all of the witnesses who helped the committee with our inquiry. And again, I thank our tireless clerks and SPICE for all their work in supporting the committee through what was a very fast-paced inquiry. I also thank the government for its response to our Stage 1 report, which was received earlier this week. Presiding Officer, our report focuses really on two concerns. The first is whether the new powers contained in the bill are necessary and how they will fit alongside the plethora of other powers which the criminal justice system already has to deal with family disputes and domestic abuse. And the second is whether the new powers are compatible with Scotland's human rights obligations. Let me say straight away that the committee had no hesitation in supporting the policy intentions underpinning this bill. The committee supports the underlying policy intentions wholeheartedly and unanimously. But good intentions, whilst they are a necessary ingredient of good law, do not of themselves guarantee that the law we make is fit for purpose. And the committee has been anxious to ensure the powers conferred by the bill are capable of being operated and implemented effectively. The committee's anxieties in this regard were amplified, I think, when we took evidence from Police Scotland. Detective Chief Superintendent Samantha McCluskey told us that she had a variety of doubts and puzzles about how the new powers contained in the bill, and in particular the power to issue a domestic abuse protection notice, are to work in practice. What is the evidential threshold which must be crossed before a notice is imposed? What should the police do in the event that there is not only an accusation of domestic abuse, but also a counter-accusation? This situation, she said, is very challenging for officers on the ground. How should the conditions imposed under a DAPN sit in relation to other court-imposed orders or restrictions, such as bail conditions? Could a failure to issue a DAPN open the police to potential liability in the event that subsequent abuse occurs? Whereas the police have become used to working in a multi-agency way in partnership with other bodies such as social workers, in cases of domestic abuse, it is not obvious how issuing a DAPN on a person can be undertaken other than by the police alone. In all of these operational respects, DCS McCluskey told us, clarity is needed. We need to build, she said, we need to build a bit of confidence among police officers who will be expected to make decisions and build the public's confidence in our response, end quote. So the committee drew attention to these operational challenges in our conclusions and recommendations. And the Cabinet Secretary devotes several paragraphs of his response to our report, detailing how the government, in consultation with Police Scotland, intends to ensure that these challenges are met and overcome. The government accepts, I think, and I think we've just heard this from Mr. Youssef, that some of this is going to be challenging in practice and is going to require careful implementation. And I welcome both the tone and the content of what the Cabinet Secretary has had to say about this. I want to close, Presiding Officer, by saying something about convention rights. It's clear that the powers to issue a DAPN and to make a DAPO interfere directly with human rights, most obviously the right to private and family life in Article 8 of the European Convention. Like most rights in the Convention, this is of course not an absolute right, but interferences with it need to meet two key tests. They must be necessary in the public interest, and they must be proportionate. I share the Cabinet Secretary's view that, as drafted, the bill is likely to meet both those tests. But a key component of that judgment rests on the fact that both a DAPN and a DAPO are short-term measures. The longer either is permitted to endure in any particular case, the greater the risk that a court will find a violation of convention rights. Presiding Officer, it will be seen, I think, even from this brief overview, that there is a lot in this bill. Ideally, one would have wanted to be able to scrutinise it at a less frenetic pace, but we are where we are. And the committee, whilst drawing attention to the range of issues and concerns I've outlined in my remarks this afternoon, was content to recommend, again unanimously, that the general principles of the bill be approved by the Parliament at decision time this evening. Thank you very much.
Thank you very much, Mr Tompkins. I now call Liam Kerr to open for the Conservatives. Mr Kerr, please.
Thank you, Deputy Presiding Officer. I confirm that the Scottish Conservatives will vote in favour of the principles of the Domestic Abuse Protection Scotland Bill at decision time tonight. We share the Chamber's condemnation of domestic abuse as a scourge on our society and welcome any attempt to address it and get victims justice. The rationale underlying this bill, I think, was set out, I thought, succinctly and well by the Cabinet Secretary in his remarks earlier. But it's particularly important to consider at the moment because we know from published data that domestic abuse has risen in Scotland over the last 3 years, and actually the number of domestic abuse charges are at a 4-year high in 2019-20. Now, the bill has at its core 3 basic aims. Firstly, to protect a person at risk of domestic abuse in the immediate term by the giving of a power to a senior police officer to issue a domestic abuse protection notice, a DAPN, on a suspected perpetrator of abuse. It then sets out the further legal steps that might be taken to ensure the longer-term safety of a person at risk, specifically giving the civil courts a power on application by the police to grant a domestic abuse protection order, a DAPO, for up to 3 months in relation to the perpetrator. And finally, there are protections around housing, which I'm pleased to see, as I recall when we were dealing with what became the Domestic Abuse Act in 2018, proposing an amendment to that bill which called for a review of measures that would have, amongst other things, excluded someone from a person's house if they presented an immediate danger to the other person or a child. Now, as the convener has just made clear, the Justice Committee considered this bill in a very tight timescale, and I'm very grateful to the clerks, to the witnesses, and indeed to my colleagues for the way this has been approached. That shortened time frame is important to keep in mind because I think all members take the view that whilst this is a really important piece of legislation with excellent aims, it is far from the finished product in terms of precision in drafting and practicality. Indeed, the committee was unequivocal that serious practical concerns over the bill needed to be addressed prior to stage 3 approval. And it took this position because both legal bodies and the police in particular signalled outstanding issues with the drafting of the bill, which could mean its powers perhaps not being regularly used or proving difficult to use in practice. Officers on the ground must be able to use the law with confidence. Now, I've no doubt that colleagues will talk at length on the issues, but I'd like to focus my remarks on some of the key concerns raised by the police. Police Scotland raised concerns about the unilateral decision-making outlined in the bill, particularly in relation to DAPNs. They state that the police being able to issue DAPNs without consultation, quote, is not in step with established partnership approach currently taken across public protection to address risk. And they reminded the committee that where emergency measures such as ones outlined in the bill are taken, they are usually done so with a core group of statutory partners who have a key role in decision-making from the outset. Now, Police Scotland proposed that the risk identified must be in line with sexual offence prevention orders, which are well defined. And they consider that other statutory and third-party agencies should be able to apply for a DAPO. They note of the current provisions in Section 8, in which only police can make such an application for an order that, quote, reliance on a single organisation, such as Police Scotland, to apply the legislation not only creates a significant and potentially unmanageable demand on the single service, but is out of step with the established partnership approach in Scotland. And I'm grateful to Scottish Women's Aid, whose helpful briefing today makes a useful suggestion in this regard. Police Scotland also flagged that the time frame for DAPNs creates substantial operational challenges. They flag in their written submission that the necessary IT and information sharing, additional demand on officers who, I think I heard the convener say, spend an average of 9 hours dealing with each domestic incident they attend, and the logistic implications of ensuring legal representations at hearings create substantial challenges for the police, and also require sign-off from a senior officer. Now, we heard in committee, senior officers are typically desk-based and do not routinely attend at the scene, so how this works in practice is key. Furthermore, as the committee recommended, it will be important at stage 2 to define what a reasonable excuse for breaking a DAPN or a DAPO might be, because there aren't any examples or definitions in the legislation. So in summary, Presiding Officer, these concerns include, but are not limited to, the threshold for evidential proof, something which the Cabinet Secretary has responded to in his letter, but which Scottish Women's Aid make interesting points on, the challenges of risk assessing at the scene, whether there is a conflict with the ECHR, how breaches are to be dealt with and what constitutes a breach, any liability of Police Scotland upon a failure to act, and where DAPNs sit with other court-imposed sanctions or orders relating to children. And perhaps where all that gets us to is that we need reassurances from the Scottish Government that the police will be appropriately resourced to apply the new legislation. They have to be adequately resourced to respond appropriately when assessing and imposing DAPNs or dealing with DAPOs, and then on enforcement. And this will need training, which is a money and a time thing. Now, in his response to the committee's report, the Cabinet Secretary has said he will create an implementation board which will examine how to bring in the proposed new powers of the police and courts against suspected abuse, and it will involve key partners, including Police Scotland. He writes the implementation board will carefully consider what guidance and training is required for police officers and others, and that the operational processes required to enable an application for a DAPO to be prepared in line with the timescale set out in the bill will be considered. And this is good. But leaving aside, I don't see in that the cast-iron commitment to overall resourcing. It feels a bit like it's been backloaded. Why wouldn't this have been done in preparation for the bill? The Cabinet Secretary said in his submission just now he's spoken to the Chief Constable about these issues, but oughtn't that to have been done in advance? And in the same area, I note the Law Society of Scotland, of which I remind the Chamber I'm a member, suggests that what would have helped is prior modelling to identify how and in what circumstances a DAPO would be used to provide effective short-term remedies. They further say that while some of the matters raised in the report, in the committee's report, might be picked up by the implementation board, there needs to be some effective scrutiny, monitoring and evaluation provisions within the bill, including reporting to this Scottish Parliament. So the Scottish Conservatives will support this bill, but the significant concerns about the operational and resource impacts of the bill must be addressed if it is to become law. Otherwise, it could be undermined from the start. So, in conclusion, every effort possible must be taken to prevent domestic abuse. And this bill is another attempt at addressing this vile problem in society. As ever, we will work constructively with the government to achieve that end. This bill seeks to provide victims of domestic abuse with the protection they need, and we are absolutely supportive of that principle. The Scottish Conservatives will always stand up for the victims of crime, and that is why we are very pleased to support this bill at decision time tonight.
Thank you very much, Mr Cairn. I call on Rhoda Grant to open for Labour. Ms Grant, please.
Thank you, Presiding Officer. Can I also add my thanks to the clerks, to SPICE and indeed to the witnesses who all assisted in the committee in reaching their Stage 1 report. We in the Scottish Labour Party support the general principles of the Domestic Abuse Protection Scotland Bill. Women and families facing domestic abuse need protection. Too often it is left to them to flee their home and to find their own protection through the courts at their own cost and often with very little knowledge of the justice system. They're often afraid to do this in case it triggers more violence. The point when a relationship is over is often the most dangerous for victims of domestic abuse, and this is frequently the time when abuse can become murder. It is wrong when victims of domestic abuse have to organise their own protection. Our criminal justice system should be there to protect people, and that means everybody. It is a sad reflection on our society that currently this does not happen for victims of domestic abuse. Proving domestic abuse is difficult because it is hard to identify. By its very nature, it is an offence carried out in private within the family home. It is seldom witnessed and takes many forms. Sadly, despite the work of this Parliament and subsequent governments, we still have not seen an end to domestic abuse, and this bill provides the opportunity to put in place another protection. And this is not a new concept. It's used the world over to provide additional protection. It's disappointing, therefore, that the bill is a bit of a dog's dinner. It feels like whoever designed it did not really understand the systems that exist, nor the very nature of domestic abuse. And I sincerely hope that this Parliament will be able to make this legislation workable as it makes its way through stages 2 and 3. Domestic abuse has a detrimental effect on a child's life. Their resilience, their self-esteem are damaged with it, and with that, their life chances. They do not even need to witness it or experience it themselves. The tension and fear that surrounds them creates fear and insecurity within them. While children are offered protection under this bill, this protection is attached to their parent. I truly believe that children must have access to this protection in their own right. The NSPCC reported a 30% increase in referrals to agencies regarding children in abusive households since last April. This at a time when children are more isolated, trapped in abusive households without the respite and support of going out to school. Domestic abuse itself has increased, and therefore the impact on children has increased. If children are contacting agencies for support when they witness domestic abuse at home, surely they themselves should be entitled to protection to have that abusive parent removed. And this happens in other countries such as Australia and New Zealand. It is not used very often, but it can be another protection for children. The nature of domestic abuse is that the victim often covers up the crime because they fear retribution or a total lack of self-esteem which has been removed systematically by the abuser. Therefore, it's important that all victims have the right to this protection. An issue that was raised regarding domestic abuse protection notices and how they interact with orders such as home detention orders or court orders regarding the custody of children needs to be clarified in the legislation. Notices are an emergency intervention. They require no judicial oversight and can be put in place by a senior police officer. Therefore, it needs to be very clear in the legislation how and when these notices take precedence over other orders, especially those handed down by a court. It is right that notices do have precedence in an emergency, but that needs to be clear in the bill. If a domestic abuse protection order is subsequently sought, then there will be oversight by a sheriff and steps can be taken to resolve any conflicts that may occur with orders during the court process. For instance, if the subject of the notice is a home detention order, there will need to be a mechanism for their home base to be changed for implementation of that order. And some witnesses said that to have a notice imposed might indicate a breach of a home detention order and therefore a return to prison might be required. However, given that a notice is only issued where there is no proof of a crime to enable the subject of the notice to be arrested, charged and held in custody, I am unclear how that could be considered as a breach of a home detention order. There are also child custody arrangements which have been imposed through a court, and we need to clarify how they interact with notices. We often hear of terrible cases where child custody and access rights are imposed by the court and that they leave the victim of domestic abuse in life-threatening situations. Access arrangements are often used to continue the abuse using children as weapons, which not only damages the victim but also the child. And that is yet another reason for a child to have those protections in their own right. All this needs to be very clear on the face of the bill. It needs to be clear that these notices and orders take precedence over any contact or custody rights of the person subject to them. Notices and orders also bar someone from entering their own home, and there is a reason for that. Too often we see the victim of domestic abuse and their children having to flee their home and become homeless. This bill will help to ensure that they can remain in their own home. However, the bill is unclear on what steps will be taken to ensure the subject of the notice has access to housing immediately if they have nowhere else to go. And this is important, especially if they are subject to a home detention order that keeps them at that home, and also important to avoid homelessness. It is right as well that the abuser is forced to leave their home, because that allows the person who is being abused to remain at home with their family. Presiding Officer, the bill is necessary, but the framing has not been well thought out. I hope the committee, working with the Cabinet Secretary, can put that right at stage 2, because if in good order, this bill will provide a lifeline to victims of domestic abuse.
Thank you very much, Ms Grant. I now call Liam MacArthur to open to the Liberal Democrats. Mr MacArthur.
Thank you, Deputy Presiding Officer. Scottish Liberal Democrats strongly support any attempt to improve the protection for those at risk of domestic abuse, particularly where they are living with the perpetrator of that abuse. In that context, we will be very happy to support the principles of this bill at decision time today, not least as they broadly reflect the policy adopted by Scottish Liberal Democrats back in 2019. That said, and as others have mentioned, it's clear work is needed to address practical concerns raised by various witnesses at stage 1, not least Police Scotland. However, let me start, as others have done, by thanking all those who have helped the committee to get to this point, notably witnesses giving both written and oral evidence, our clerks and Spice. They and we, I have to say, have not been helped by a truncated timeframe for scrutiny referred to by the convener, but given the nature and the complexity of the issues raised by this bill, that is far from ideal, Deputy Presiding Officer. But the principles are sound. They reflect those of the Istanbul Convention and already in place in countries such as the Netherlands, Austria, Germany, Spain, as well as England and Wales, all of whom have introduced short-term protective orders aimed at tackling domestic abuse. In Scotland, as the Cabinet Secretary reminded us, current civil measures place the onus on the victim to apply for orders. Under this bill, police would be able to impose a protection notice and thereafter apply to the court for a protection order, which could place requirements and prohibitions on a suspected perpetrator of domestic abuse. These include removing a suspected perpetrator from a home shared with a person at risk of abuse and prohibiting them from contacting or otherwise abusing the person at risk while the order is in effect. As well as protecting those at risk of domestic abuse, we need to improve outcomes for victims in relation to housing, creating a new ground on which a social landlord can apply to the court to end the tenancy of a perpetrator of abusive behaviour with a view to transferring the tenancy to the victim is another welcome step. This matters. We know there are over 60,000 domestic abuse instances recorded by Police Scotland in 2018-19. At the same time, around 4,500 homelessness applications were made due to a, quote, violent or abusive dispute within a household. The vast majority of those applications were from women, half of whom had children. Domestic abuse is the single biggest reason for a homelessness application by women. Those alarming numbers were on the increase before COVID. Nobody seriously expects that trend to have been reversed during the pandemic. Indeed, quite the reverse, as the NSPCC reported earlier this month. So the provisions of this bill are both welcome and timely. Nevertheless, in a practical sense, as the committee heard repeatedly, the bill, as drafted, lacks clarity. The Law Society cite a risk of, quote, proliferation of potentially overlapping measures. Indeed, the government acknowledged the existing criminal and civil law provisions that could be used to remove a suspected perpetrator of abuse. Thresholds for DAPNs also give rise to concerns, with the Law Society given the evidential basis required for police to take such a step. This would need to be proportionate to be consistent with an individual's ECHR rights. But DAPN can only be imposed by a senior police officer at the rank of inspector or above. How would this work in practice? There was also some disquiet over the threshold for taking action, as reasonable grounds to believe is at odds with the existing threshold, opening up the potential for confusion. While this is not a power that witnesses expected to be used extensively, greater clarity is nevertheless essential. On the question of what the maximum duration of a DAPO should be, the committee heard mixed views. Scottish Women's Rights Centre and Scottish Women's Aid argued the proposed 3-month period was too short, but concerns were also expressed about the ECHR implications of going beyond that, which I and committee colleagues certainly understood and sympathised. On whether consent of those deemed at risk should be sought before implementing a DAPN or a DAPO, this may be problematic. The committee heard compelling evidence, though, about the need to ensure women's voices are heard and reflected in the process, and the bill will need to find a way of achieving this. And while an automatic referral to support organisations may be a step too far, presumption or even an opt-out provision, as proposed by Scottish Women's Aid, does not seem unreasonable. Police Scotland assured the committee that such referrals routinely take place. Placing such a provision in the bill may offer further reassurance. Finally, I think the point made by the Shetland Domestic Abuse Partnership about the age thresholds is one that deserves further consideration. A perpetrator need not be 18 or over and can be as young as 16. And I think the bill needs to reflect that fact. This is also a reminder that domestic abuse sadly blights every community across Scotland. In my own constituency, Takistan, Orkney, it does happen here. It effectively says it all, and I commend them for the work that they do in encouraging the reporting of abuse. Deputy Presiding Officer, this is an important bill that can deliver real improvements for those affected by domestic abuse. However, changes are needed at stage 2 to give it the clarity, certainty and scope it requires to be effective. I look forward to working with committee colleagues to achieve that goal. In the meantime, Scottish Liberal Democrats will, of course, be supporting this bill at decision time. Thank you.
Thank you very much, Ms McArthur. And I call on John Finney to open for the Green Party. Mr Finney, please.
Thank you very much indeed, Presiding Officer. And like colleagues, the usual thanks to everyone that's brought us to this point. I want to say at the outset that the legitimate criticism of this bill is not at odds with my unequivocal support to arrest the scourge of domestic abuse. Like others on the committee, I've been active in the field and declare an interest as a member of the cross-party group of men's violence against women and girls. However, we don't make laws for the sake of it. We want to make good law, effective law, law that's evidenced as being needed, law that will make a positive difference. Domestic Abuse Scotland Act 2018 was covered by the Justice Committee, and that overhauled the criminal justice approach. And it did identify a gap, and that gap was, and I quote here, keeping a perpetrator away from home. So that does equate to a need for a law. And of course, that stems from the Istanbul Convention, which the Scottish Government expressed in their commitment to equally safe, and that states that there should be legislative measures to ensure that in situations of immediate danger, a perpetrator of domestic violence is required to vacate the residence and prohibit the perpetrator from entering the residence of or contacting the victim or person at risk. Now, that approach is necessary and seems very straightforward. Unfortunately, this legislation, or at least its application, isn't. Police Scotland seem uncertain how they might use the power. They talk about exceptional circumstances. Members of Parliament scrutinising legislation need to understand how it will work. Policy aims are very clear, protecting a person from immediate risk, and that's good, and the bill could do that. But what if the alleged perpetrator has left the scene? What role does the bill have for that? Do police have power to detain pending the granting of a DAPN? Is such a power in the bill or elsewhere? It's talking about the policy aim of creating time for any further legal steps, but the time frames are tight. It's the next lawful day. What if following the granting of a notice, the court decides not to grant an order? Been alluded to by other members, the Law Society talk about the risk of proliferation of overlapping measures, and it's fair to say that Scottish Women's Aid don't see it like that. They say that these measures are not intended to replace existing criminal measures. And the routine criminal justice response should always be the first consideration. They say it's for a very specific situation in which it is not possible to use criminal justice measures. If that's the case, one might reasonably ask, what happens at the moment in the circumstances in which this bill is intended to work? Nothing? Hopefully not. And if there is a gap, and I think we accept there is, does this bill fit the gap? The policy memorandum of the bill itself talks about a number of existing criminal and civil law provisions currently in effect, which can be used to remove a suspected perpetrator of abuse from a home they share with a person at risk and otherwise prevent contacting a person at risk. My wish, the committee's wish, is to understand where these proposals fit with the existing arrangements. Another policy aim to reduce the chances that the person at risk becomes homeless or feels that he or she, rather than the suspected perpetrator, must find where new to live. What of the suspected perpetrator? Someone for whom there may be insufficient evidence to arrest, someone for whom may not be subject to investigative deliberations, some from whom there may be insufficient evidence to take to court, is a police officer to deny that individual their residence. Now, the Scottish Government, in the response here, I would like to take this opportunity to clarify that a senior constable in making a DAPN will not be acting as a court of law. Really? It seems to me that that's not a particularly helpful response. I would argue that acting as a court of law is exactly what the bill is asking officers to do. That's precisely why there must be no debate about what's expected of them, what proof, what evidence is needed. I say again, sanctioning police to advise an uncharged, unconvicted person, someone who may be subject to no other civil or criminal restraints, where they can go, who they can engage with, where they can stay, is a big step. Every officer, every police officer has to justify their decision-making, has to explain the rationale, particularly in placing restrictions on citizens. An officer will ask themselves, what are my powers? In what circumstances can I exercise them? And of course, what's the right of redress for the individual? I'll not, the policy notes do talk about the likely interference with rights, and that's been touched on with others. So in the limited time, I acknowledge that that is covered. But of course, the Justice Committee had significant concerns about the practicalities of Police Scotland being able to use powers in the way they're intended. Now, the Cabinet Secretary tells us there's further consultation with Police Scotland about how the powers can be used. The British Government should be well down the road from there. Compelling evidence from Police Scotland and the Law Society and others that further consultation and clarity is required on how these DAPNs are expected to work is actually quite a serious criticism of being at this stage of the legislative process. In relation to breaches, we're told by the Scottish Government response, I consider the bill as clear. If clear, can the Cabinet Secretary outline what legal power there would be to detain someone who is not under arrest pending the issue of a DAPN? My mind works in the like flowcharts. I like to know what the options are, and if it was laid out in that way, or as the Law Society more correctly put it, prior modelling to identify how and in what circumstances, that would be very helpful. I'm conscious of time, Presiding Officer. It's reasonable to expect greater clarity about this legislation. These are exceptional powers, and we're told they'll be used in exceptional circumstances. It may be that I'm very slow in the uptake. A sample scenario would be of great help. Of course, the reality for victims is very bleak, and the bill can play a part in resolving that, but only if we resolve all these issues. And I'll leave it there. At Decision Time Party will be supporting the bill.
Thank you very much, Mr Finney. I do remind members there's a little time in hand to run over their time. Rona Mackay, open debate. Rona Mackay, followed by Rachel Hamilton.
Thank you, Presiding Officer. It cannot be overstated how important the bill we're debating today is to the victims of domestic abuse, and I'll be more than happy to pass the general principles at stage 1 today. Firstly, can I thank the clerks and the bill team for their exceptional work in preparing the stage 1 report within an extremely tight time frame. There's much ground to cover in the detail of this bill, but I know that what I can't cover, colleagues will pick up in their contributions, and indeed many already have. The Domestic Abuse Protection Scotland Bill is indeed a milestone. Orders issued will provide emergency safety measures to victims, 80% of whom are women and children, by removing the alleged perpetrator from the home and barring contact with the person at risk. It's a safety net for those who so desperately need one, and it will improve the outcomes for housing victims by giving social landlords the power to end the tenancy of a perpetrator. Domestic abuse is the main cause of women's homelessness in Scotland. Crucially, it gives the police the power to issue a domestic abuse protection notice ahead of applying to the civil court for a domestic abuse protection order. The significance of this is huge. It means the victim at her most vulnerable does not have to go through the court process herself and doesn't incur legal costs. Of course, these orders are not intended to replace existing criminal measures, but they will protect victims in cases where it's not possible to apply this, but there is an imminent risk to safety. Presiding Officer, evidence received by the committee questioned whether there was a legislative gap to fill, given that we have non-harassment orders, civil protection orders and emergency barring orders. My view is that there most definitely is, and that these orders will fill that gap, providing immediate safety to victims by removing the perpetrator and barring further contact. Until now, it's traditionally been women and children who are forced to leave the family home in cases of domestic abuse. This is unfair and inhumane for both the victim and the children. To be uprooted from their home, school and familiar surroundings through no fault of their own, they are guilty of nothing, yet they pay the price. That's why these orders are so important and necessary, particularly now with levels of domestic abuse soaring during the pandemic. Dr Marcia Scott, Chief Executive of Scottish Women's Aid, said, "The publication of this bill is a milestone moment for women, children and young people experiencing domestic abuse, who for years have asked us why it should be them rather than their abusers who have had to leave their homes, pets and belongings to seek safety." Presiding Officer, in its Stage 1 report, the committee spoke of real operational concerns in respect of Police Scotland. The convener and other speakers have articulated many of those well, so I won't repeat them here. However, I am extremely pleased that the Cabinet Secretary has said who will continue to engage with Police Scotland and key stakeholders to discuss their concerns. Good legislation must be workable legislation. To that end, the Cabinet Secretary has confirmed that he will set up a Scottish Government-chaired implementation board to examine all matters relating to operational matters if the bill is passed. Presiding Officer, the timing and length of DAPNs and DAPOs featured heavily in our evidence taking. In order to be ECHR compliant, there is a short timescale for the Senior Constable proposing the DAPN order to apply for a court order, and the committee accepts this. The duration of a DAPO is a maximum of 3 months with some flexibility for extension in certain circumstances. And again, we believe that this is reasonable given that these are emergency orders, although there may be issues around eviction and rehousing, and this could be addressed at stage 2. Presiding Officer, I am passionate about this bill, and I'm particularly delighted that a breach of an order is a criminal offence. One of those breaches would be stalking by a partner or ex-partner where an order has been issued. More than half of stalking offences are committed by an ex-partner. In 2019, I introduced a Members' Bill proposal to introduce stalking protection orders which the police could apply for on behalf of the victim. The proposal was paused in order to evaluate the effect of the newly introduced Domestic Abuse Scotland Bill. If the bill we are debating today is passed, another legislative gap will be filled, and I couldn't be happier. However, we know that stalking usually takes place over a period of time and may last longer than 3 months if no arrest has been made. So I will consider bringing forward an amendment at stage 2 to ask that the order is eligible for extension in cases of stalking breaches. Section 4 of the bill relates to the police paying attention to the victim, quotes, only when they are aware of the woman's views. Presiding Officer, I believe women and children's views should be actively sought, as should the consent of the woman to an order. To issue an order without consent would be to further disempower the victim. In a case where coercion is suspected, and that is very often the case, an interim order could be issued without consent to allow time for further investigation with a view to taking criminal action. In relation to the evidential threshold for issuing an order, as the Cabinet Secretary has outlined, women's organisations have expressed concern over the wording of significant harm in the government's response to the committee, and I'm sure this is something else that could be addressed at stage 2. So in conclusion, Presiding Officer, there is so much to welcome in this bill. At last, abused women and children will have emergency protection that has so far been lacking, a safety net for them and any children involved. There are issues to be resolved, as we've heard, but I know that the government will work with stakeholders to make this vital piece of legislation work for everyone. We owe it to so many silent victims living in fear. Presiding Officer, this legislation is the beginning of the end for perpetrators of abuse, and I urge members to pass the general principles at decision time today. Thank you.
Thank you very much, Ms Mackay. I now call Rachel Hamilton to be followed by Fulton McGregor. Ms Hamilton, please.
Thank you, Presiding Officer. I welcome the Domestic Abuse Protection Scotland Bill at stage 1 here today. Scottish Conservatives will always stand up for victims of abuse and support the general principles of the bill. Scottish Women's Aid and the Law Society, to name a few, have welcomed the bill's proposed powers, which are intended to fill a gap in legislation, or as my colleague Adam Tompkins said, sharpen the effectiveness of the tools we have for those who may be experiencing abuse. This with an aim to reduce the risk that a person has to make themselves homeless, provide them with a safe pathway to other forms of safety. Sadly, we know domestic abuse is on the rise in Scotland. The number of domestic abuse incidents recorded by Police Scotland has been rising in the last 3 years, from 58,108 in 2015-16 to 60,642 in 2018-19. It is concerning that we see the number of incidents is rising. However, as I've previously said in this chamber, it must be looked through the prism that perhaps more victims feel confident and empowered to come forward. I want to thank the important work of my local women's refuge, Border Women's Aid in Hawick, who have worked tirelessly to help other women gain freedom from abusive relationships. They provide safe accommodation and specialist support for up to a year for women and their children who have left abusive homes. Through their excellent outreach service, they support many women in the community currently living with abuse while they plan for a life beyond. We've come a long way in supporting victims. However, there is still a lot more work to be done. I believe that legislation must go further in tackling some of the issues of domestic abuse that occur post-separation, and I will touch on these later in my contribution. However, I want to make two main points today in relation to the bill at this stage and how we can further strengthen it to help assist and empower victims. Many other members in the chamber today have discussed both of these issues, and firstly, we welcome the two new powers for courts to make a domestic abuse protection order and for the police to make a domestic abuse protection notice, but have concerns about their implementation. I want to thank my colleague Liam Kerr for raising these points in the 2018 bill. He proposed an amendment to the bill which would have called for a review of measures that would have, amongst other things, excluded someone from a person's house if they presented an immediate danger to the other person or child. The Justice Committee, the Law Society of Scotland and Police Scotland have noted issues with the current drafting of these powers. The Law Society have questioned Section 4 of the bill and whether a DAPN is a proportionate measure in the context of the relevant rights under the European Convention on Human Rights. It remains uncertain how a DAPN will be issued in practice, and the bill does not appear to have a specific power available to the police to remove a suspected perpetrator to the police station relating to a DAPN. The committee have noticed these concerns, and they will have to be dealt with at stage 2 and through proper consultation with Police Scotland to ensure that the new powers are fit for purpose and effective. Secondly, if I may, I'd like to touch on the important issue of financial abuse, especially post-separation. We know that when a victim leaves a perpetrator, there can still be ties which unfortunately link them to that person. Lack of money and financial resources is the main reason why women return to abusive partners post-separation. And economic barriers and a lack of financial independence are the main factors in women staying in those abusive relationships. 1 in 5 women and 1 in 7 men in the UK have experienced financial abuse from a current or former partner, according to the Cooperative Bank and Refuge, and 1/3 of victims didn't tell anyone at the time. We know the UK government has provided 22 million in support of domestic abuse and sexual violence in the community access support services and 10 million for domestic abuse safe accommodation charities, which has helped many people in difficult situations. Just this week in the House of Lords, Baroness Lister has been instrumental in bringing amendments to the committee stage of the UK Domestic Abuse Bill. Her amendments seek to ensure that those who were previously personally connected with protected from any coercive and controlling behaviour, including economic abuse that occurs post-separation. Post-separation coercive and controlling financial abuse is widely recognised. I am glad that banks such as the Bank of Scotland and RBS have been supportive of victims and set out guidance and best practice for employees on how to treat sensitive situations, such as victims accessing bank accounts or closing accounts with abusive partners. In the Domestic Abuse Scotland 2018 Act, there are provisions to cover coercive behaviour, even if they are ex-partners. Under this new Domestic Abuse Bill, Section 3(3)(c) refers to controlling, regulating or monitoring person B's day-to-day activities. I'm not a member of the Justice Committee. However, I wonder if the Cabinet Secretary in his closing remarks could clarify if financial abuse post-separation is covered in this bill and if the new notices and orders are able to deal with coercive financial abuse post-separation. In conclusion, Presiding Officer, we on these benches support the general principles of the bill. Nonetheless, there are issues which require addressing. Concurred by my colleague Liam Kerr, many stakeholders, such as Police Scotland, have significant concerns about the operational and resource impacts of the bill. These must be addressed if the bill is to become law. Otherwise, it could potentially undermine any convictions that take place under the bill. What is crucial to the efficacy of this bill and the tackling of domestic abuse is the proper financing and resourcing of our police force to ensure that they can continue their good work. I urge the SNP government to make sure our police officers are fully equipped to root out this evil, which continues to be a scourge on our society. The support groups, charities and victims of domestic abuse are what need to be listened so that the Scottish Government can get this right. Thank you, Presiding Officer.
Thank you very much, Ms Hamilton. Now call Fulton McGregor, followed by Polly McNeill. Mr McGregor, please.
Thank you, Presiding Officer. As a member of the Justice Committee, it gives me great pleasure to speak in this bill today. As we have heard, this bill builds upon the important legislation that came into force last year and allows police and prosecutors the powers to ensure that those who participate in coercive or controlling behaviour that are held accountable for their actions. And make no mistake that such behaviour is domestic abuse and it is now treated as such. Presiding Officer, cases are going up and that should not be surprising. It may not necessarily represent higher prevalence, but rather people feeling more able to report and a clear message from this government and from society that it will not be tolerated. And that is something that we should welcome. However, in addition, this bill will offer additional protection to those at risk of domestic abuse, especially in cases where they are living with the abuser. Someone should feel safe in their own home, and it couldn't be more timely than now during these times of lockdown when we cannot leave our homes. Yes, more money and restriction exemptions have been put in place to support those suffering the reality, but the reality still remains that lockdown negatively impacts victims of domestic abuse. These might be about concerns about household mixing and virus transmissions, meaning that options to move in with other family and friends may not be as readily available as they usually would be. People may be unclear if they can leave a situation or may even be told by an abuser that they cannot. Kids not being in school, as we've already heard from Rona Mackay, and of course the massive strain on our emergency services. All of this means that many victims are suffering in silence, and now even more so at this time. Presiding Officer, this new bill will apply to all those at risk of domestic abuse, but we do know that women are disproportionately affected, representing around 80% of victims. The Scottish Government is determined to protect everyone from domestic abuse and at the same time will continue to implement the Equally Safe strategy, a focus on supporting women and children at risk of abuse. With this new bill, police and courts will gain powers to remove suspected abusers from victims' homes, ban them from re-entering under new legislation. A domestic abuse protection order will now come into force if this bill passes, allowing courts to impose requirements upon suspected perpetrators. The order will allow for the removal of a suspected perpetrator when they share it with someone at risk and contact will no longer be allowed. The bill also provides power for the police where necessary to impose a very short-term domestic abuse protection notice ahead of applying to the court for a DAPO. The DAPN, the protection notice, is intended to be very short-term in its effect, lasting until the court reaches a decision about whether to impose a DAPO or an interim DAPO. The bill proposes that a DAPO could last for up to 3 months in total, as we've already heard. In committee, we heard from witnesses in support of this, including Scottish Women's Aid, the Scottish Women's Rights Centre and Professor Mandy Burton of the University of Leicester, who all believe that there is a need for new powers, as in their view, a gap does exist currently in the protection afforded to women under existing powers. Another aspect of the bill, which is quite groundbreaking, is social landlords will now have the powers to end or transfer a tenancy of a perpetrator of domestic abuse to prevent a victim becoming homeless and enabling them to remain in the family home. Tenants affected by domestic abuse should not have to leave their family home. We all agree on that. It is often the case, though, that children are also shared in such a situation and thus make it harder for someone to find suitable accommodation, and the upheaval can be deeply traumatic on top of what has already taken place. It is recognised that by allowing for a transfer of tenancy, victims and their families will be able to stay in their home without having to seek temporary accommodation or declare themselves homeless. Many victims indeed will stay in a relationship with their abusers due to the fact that they have nowhere to go and cannot fathom the ordeal of leaving their home and finding suitable accommodation. This part of the bill will help put a stop to that and help redress this imbalance that has been around for some time. As we have already heard, however, there are, of course, some issues to be discussed further at committee. The bill is not the finished article, and I think it's fair that we need to say that, and every speaker, including the Cabinet Secretary, has reflected on that today. For example, there have been concerns raised over the suggested level of the evidential threshold, which would enable a domestic abuse protection order or a domestic abuse protection notice to be made. And the Justice Secretary, as we've heard, has confirmed a Scottish Government-led board will be established to ensure the effective implementation of proposed new measures to protect victims of domestic abuse. There were also concerns, as we've heard from several speakers, around significant operational and resourcing challenges for Police Scotland, and I'm also delighted that the Cabinet Secretary has indicated that there will be ongoing with Police Scotland on these issues, because from the evidence we hear will quite clearly be required. Shared parents in Scotland have raised concerns around the compatibility with human rights, as we've also heard from the convener and others, including that the alleged perpetrator, who is subject to a DAPN or a DAPO, may or may not have actually committed the offence. And I think those with these concerns can be reassured today in this debate that they have been heard and considered by the committee, but also understand that we need to balance these concerns against not doing more to protect victims and the devastating consequences that can occur when we do not act decisively. So much like the previous domestic abuse legislation that this committee looked at, it's important for people to know that the committee does take into account all these issues, but we have to have balance when doing that. And also, as we've heard, Women's Aid have played an instrumental role, presiding officer, in the development of this bill, and I've made some further recommendations to members to improve it, and these include in section 1 strengthening the definition on application of DAPNs, in section 4 a more robust duty to actively seek views of women and, where practical, children, and appropriate wording around the test and thresholds of imminent risk. In section 8, a more robust duty to actively seek views of children, the need for consent of women, and amendment to categories of applicant for a DAPO. And finally, they suggest in section 9, section 13 and section 18, extending the duration of DAPOs to allow section 18 proceedings to conclude. But we have also heard concerns about that, as Liam MacArthur pointed out. However, I welcome the Cabinet Secretary's engagement with Scottish Women's Aid on these issues, and I do think that, given their expertise in this area, that going into stage 2, we need to consider all of these suggestions very carefully as we move the bill through Parliament. Presiding officer, I'm not actually sure of my time because I'm at home and I've not set a clock, so my apologies, but I will conclude by saying that I'm confident that this bill will make much needed changes to the lives of victims of domestic abuse, and I would urge members to support the general principles at decision time. Thank you.
Thank you very much. I now call Pauline McNeill to be followed by Shona Robinson.
Presiding officer, first of all, thanks to the Justice Committee for their close scrutiny of this important piece of legislation. The pandemic has sparked a plague of domestic violence that the UN had called a shadow pandemic. We're told to stay at home and stay safe, but unfortunately, for a lot of women, their home is not safe. Close the Gap note that 1 in 4 women experience domestic violence in their lifetime. And it's not just physical abuse that women are often subjected to, as we've heard from other members. It's coercive control too, and the 2018 bill sought to criminalise that control, a very significant development in the law. The lockdown inadvertently has given abusers the means to further restrict their partner's freedom and threaten their safety. Women's Aid reports that 2/3 of survivors identifying as currently experiencing abuse told the organisation that their abuse had started during lockdown restrictions or the COVID-19 virus had its consequences. The existing system of civil protection orders in Scotland offers predominantly longer-term protection to the person at risk, and what the bill seeks to do is add new immediate or short-term powers, so to add the legal resource for people at risk of domestic abuse. This bill brings us into step with a range of other countries such as England, Wales, the Netherlands, Austria, Germany and Spain, as other members have identified, which have introduced short-term protective orders aimed at tackling domestic abuse. And the bill proposes 2 new powers which do not require the consent of the person at risk to be exercised. The power available to a senior police officer to impose a domestic abuse protection notice, a DAPN, on a suspected perpetrator of abuse. The power available to the civil court on application by the police to grant a domestic abuse protection order in relation to the perpetrator of abuse. And the bill proposes that it would last up to 3 months in total. These new powers would only have legal effect in Scotland, but not the rest of the United Kingdom. As we've heard, while the vast majority of victims of domestic abuse are women, children are also victims too. Children experience both in short and long-term cognitive, behavioural and emotional effects as a result of witnessing domestic abuse. And only this week it has been reported that the NSPCC is concerned that over the pandemic period, the risk of young people suffering terrible consequences of domestic abuse has intensified. And increasingly, the NSPCC helpline for adults are worried about children, and have heard from neighbours reporting and hearing children crying and incessant arguing in nearby homes. The average monthly number of referrals over domestic abuse from the NSPC to Scottish agencies like the police and local authorities has risen from 32 in the first 3 months of the last year to 42 in the last few months. And it calls on the NSPC helpline, which has risen by over 50% across the UK. Joanna Barrett from NSPCC Scotland said this week, the families facing increasing pressures behind closed doors and lockdown restrictions have made some children more vulnerable to experiencing domestic abuse, as well as others. We believe that the protections in the bill need to apply equally to children who may have themselves be direct victims of abuse. Part 2 of the bill, section 18, that others have mentioned, proposes a new power for social landlords to end a tenant's interest in a tenancy where there has been domestic abuse. And this was a matter that was brought to my attention by the Chartered Institute of Housing and Scottish Women's Aid. So this section is to help tenants affected by domestic abuse remain in a family home and help avoid a move into temporary emergency accommodation. And I want to note the contribution of the Homelessness and Rough Sleeping Action Group, as well as Scottish Women's Aid, as I said, have done incredible work in this area. Dr. Marcia Scott, Chief Executive of Scottish Women's Aid, said that domestic abuse is the leading cause of women's homelessness in Scotland, a point made by Liam MacArthur as well. They've long said emergency protective orders will make an immediate and significant difference for those women and children, offering respite and breathing space as they seek support and safety. So the role of landlords is key in this, but I think, as other members have said, it's one of the aspects of the bill that does need tested to make sure that it's compliant with human rights law. And I do have a question for ministers in closing, if they could clarify whether, if the perpetrator is removed from the home, what would happen as an obligation to house them. In conclusion, Presiding Officer, I support the general principles of this legislation. Once again, I think the Scottish Parliament has shown that it's leading the way in challenging domestic abuse, the women and children and others affected by domestic abuse. And I think this legislation, as it goes through Parliament, through its scrutiny, will make a very significant contribution. Thank you.
Thank you very much. I now call Shona Robertson.
Thank you. Presiding Officer, like others, can I begin by thanking the Justice Committee clerks for all their hard work on this bill so far, and also the witnesses who have provided extremely valuable evidence to our committee. The COVID-19 pandemic has highlighted the importance of protecting women and girls who find themselves isolated and vulnerable due to the actions of an abusive partner. The stay-at-home message has been particularly difficult for many women who are victims of domestic abuse, as their home is not a safe place for them to be. In the year 2018-2019, reported incidents rose by around 2%, but in the early part of 2020, particularly during the first lockdown period, due to the pandemic, incidents were 9% higher than the equivalent period the previous year. This new bill will apply to all those at risk of domestic abuse, but we know women are disproportionately affected, representing 80% of victims. And of course, it builds on previous legislation coming into force last year, giving police and prosecutors greater powers to target those who engage in coercive or controlling behaviour. A person's home should be a place of safety, and the new orders being introduced will give victims of domestic abuse the space and time to address their longer-term safety and housing situation. The bill creates additional protection for people who are at risk of domestic abuse, particularly where they are living with their abuser. The police and courts will gain powers to remove suspected abusers from victims' homes and ban them from re-entering under new legislation. The bill will also allow social landlords to end or transfer a tenancy of a perpetrator of domestic abuse to prevent a victim becoming homeless and enabling them to remain in the family home. This was welcomed by Dr. Marcia Scott from Women's Aid, who said, "Domestic abuse is the leading cause of women's homelessness in Scotland, with women often facing the impossible choice between living with an abuser and making themselves and their children homeless." The bill creates additional protection for people who are at risk of domestic abuse by trying to fill a gap by allowing immediate protection for a short term for a person who experienced domestic abuse in order to keep them safe while they work out their next steps. The police and courts will gain powers to remove suspected abusers from victims' homes by providing courts with the new power to make a domestic abuse protection order, which can impose requirements and prohibitions on a suspected perpetrator of domestic abuse. This, as I said earlier, includes removing them from a home they share with a person at risk and prohibiting them from contacting or otherwise abusing the person at risk while the order is in effect. And the bill also provides a... Yes, of course.
Liam Kerr.
I'm very grateful to the member. I just wonder where she is on whether consideration should be given to allowing third-party organisations such as victims groups to file an application for DAPO.
Yeah, I have some sympathy for that. I think it's something that we need to explore further to make sure, like, which organisations would that be, and that wouldn't be without its difficulties. But I think it's something as a committee we should explore further. The bill also provides a power for the police, where necessary, to impose a very short-term domestic abuse protection notice ahead of applying to the court for a DAPO. Barnardo's Scotland said that they welcomed the measures contained in the bill and that the new legislation would protect and safeguard victims and their families. They stated that often abuse victims don't want to move out of the home because they don't want their children to experience upheaval. It's imperative that, where possible, the perpetrator is held to account and removed from the family home. The bill also allows social landlords to end or transfer the tenancy of a perpetrator of domestic abuse to prevent a victim becoming homeless and enabling them to remain in the family home. And Part 2 of the bill proposes a new power for social landlords to do just that. The bill is intended to help improve the immediate and long-term housing outcomes for domestic abuse victims who live in social housing. And I think that is something that is extremely valuable by creating a new ground on which a social landlord can apply to the court to end the tenancy. Alternatively, an application can be made to end the perpetrator's interest in the tenancy where the perpetrator and victim are joint tenants and enable the victim to remain in the family home. So these are important measures. So in conclusion, Presiding Officer, I am pleased that the Justice Committee has backed the general principles of the proposed legislation, while of course highlighting some of the issues to be considered further and of course making recommendations about how the enhanced protective orders would operate effectively. I want to welcome the commitment given by the Cabinet Secretary for Justice to establish an implementation board to ensure that there's clear guidance on the use of this legislation. As mentioned by the Cabinet Secretary himself and other members, there are issues requiring further consideration, one of which includes concerns over the suggested level of the evidential threshold, which would enable a domestic abuse protection order or a domestic abuse protection notice to be made. Others concerned operational matters, particularly raised by Police Scotland, as other members have already referred to. So I do welcome the Cabinet Secretary's commitment to continue to have discussions with stakeholders around their concerns about this and other matters raised in the Stage 1 report as the bill progresses to the next stage.
Thank you very much. We now move to closing speeches, and I call on Rhoda Grant.
Thank you, Presiding Officer. It has been an interesting debate, and what is very clear is that this bill is required and it has the potential to save lives, so we need to get it right. It has unanimous support, but also there are concerns expressed around the Chamber about how it has been drafted and how it will work in practice. John Finney asked if this bill fills a gap, and sadly there is a gap that needs to be filled, with victims often being forced to leave home and become homeless because they have suffered abuse. And many will return home unable to cope with the homelessness, and the abuse continues. Indeed, if anything, it gets worse because the perpetrator knows their victim has no other options. And as Shona Robertson said, many just simply stay anyway because they cannot face the homelessness that could occur if they decide to leave. A number of speakers talked about the evidential threshold for using a DAPN or a DAPO. Many spoke about how people would know when those should be used and whether or not significant harm should be an issue. And I believe that that bar is far too high. I agree with Rona Mackay when she calls for caution about setting a bar. How can we define significant harm? I believe that if there is a reason to suspect that domestic abuse has occurred or will occur, then a notice must be put in place. Pauline McNeill pointed out that the notices cover coercive control as well, and therefore any threshold put in place needs to take that into account. I, like others, welcome the implementation board to work through the concerns, but this needs to happen. Indeed, this should have happened before the bill was put in place, but it has to happen before stage 2. I think it was Liam Kerr who said it should have been done well in advance of this bill, and I agree with that. A number of speakers raised the issues that surround dealing with, that have to be dealt with in the implementation of this bill, the things that just simply do not work. Liam Kerr talked about police concerns, about the lack of partnership working, and whether or not who can apply for extensions. The DAPN is issued by an inspector or above, and that caused concerns because it was pointed out that an inspector would very seldom attend a report of domestic abuse. But perhaps this provides the checks and balances within the system, because the constable who would then attend the complaint regarding domestic abuse would have to go back to the inspector and persuade them that a notice needed to be put in place, and persuade them that they suspected that there was a risk to the victim of domestic abuse if that notice was not in place. So, however, those things have not really been laid out in the bill. So people are left wondering how it will actually work in practice. So the implementation board needs to deal with this and deal with it quickly so that we can make sure that the bill actually is fit for purpose and it does what it is supposed to do. A number of speakers also talked about the views of children and how the views not only of the victim but of the child are sought before a notice or order are put in place. With regard to a notice, this is almost impossible. Those are emergency situations where a notice is placed. But certainly before an order is put in place, the sheriff must seek the views of children and indeed of the victim of domestic abuse. And this has to be done in a way that doesn't further traumatise a child. And I'm glad that the Cabinet Secretary is looking at this. Pauline McNeill talked, and indeed so did Liam MacArthur, about the NSPCC findings and the need for protection of children. And it is quite frightening that the increase in the number of children that are seeking help due to domestic abuse during the pandemic. We must put in protection in place for them, and I believe they should be protected in their own right under this legislation. A number of speakers also talked about human rights. Adam Tompkins asked the question if these provisions were in keeping with human rights, and I believe that they are, and they are certainly in keeping with the Istanbul Convention, which the Scottish Government has signed up to. The Domestic Abuse Protection Order goes to court, so it does have judicial oversight. And the subject of that order can also make representations to that court, and therefore their human rights are not being in any way impinged. There was concerns that the length of time for both the notice and order could lead to human rights violations. The notice goes to court very, very quickly, and indeed the police expressed concerns about how quickly this needed to happen. But given that there is no judicial oversight of the notice, the sooner it is in court, I think, the better. But the order it certainly has to be long enough to allow the victim to find protection in their own right and have that put in place. Pauline McNeill also talked about removing someone from their own home and whether it was within their human rights that they would need to be rehoused. Now, we need to remember that this bill is put in place because women and children are being forced out of their own homes by domestic abuse on a daily basis. So therefore, redressing the balance to make sure it's the perpetrator that leaves is the right thing to do. But do the police have a responsibility to make sure that person is not homeless? I think we need to consider that also at stage 2 of this bill. And with that, Presiding Officer, I simply say that we are in support of the general principles of this bill and will vote for it at decision time tonight.
Thank you very much. I now call Margaret Mitchell.
Deputy Presiding Officer, I thank the Justice Committee and Clerks for the Stage 1 report and scrutiny of this extremely important Domestic Abuse Protection Scotland Bill. To put it in context, sadly, despite all the efforts to the contrary, domestic abuse is still very much with us and worse still, on the increase, with incidents recorded by Police Scotland rising in the last 3 years. More concerning still is the fact that during lockdown, abuse is known to increase dramatically as victims of domestic abuse are trapped with their abusers. While we are all encouraged to stay home and keep safe to help tackle the pandemic, the unpalatable truth is home is not safe for everyone. When the abuse, whether physical and/or coercive and controlling, becomes intolerable, victims are forced to flee the family home, with all the disruption, anxiety, and practical difficulties that entails, including finding themselves and their children potentially homeless. Under the existing civil law, where someone seeks protection from domestic abuse and to keep the perpetrator away from the home, this can only be achieved if the perpetrator enters the criminal justice system or the person at risk applies for a civil court order against the perpetrator. The bill seeks to fill what has been described a gap in the law by improving the protections available for those in a coercive, controlling relationship at risk of domestic abuse, particularly where they're living with the perpetrator. The bill provides the courts with a new power to make domestic abuse protection orders, DAPOs. These orders can prohibit a suspected perpetrator from contacting or otherwise abusing the person at risk when the order is in effect. And the police, where necessary, have the power to impose a very short-term domestic protection notice in advance of an application to the court for a DAPO. Abusive behaviour is defined as behaviour a reasonable person would consider likely to cause physical or psychological harm. The list of abusive behaviour is non-exhaustive and can include a single incident or a constant pattern of abusive action. The bill creates a new ground for social landlords to apply to the court to end the tenancy of the perpetrator of abusive behaviour with a view to transferring the tenancy to the victim, or to end the perpetrator's interest in the tenancy where the perpetrator and the victim have a joint tenancy and enable the victim to remain at home. These are good measures aimed to avoid homelessness and improve the immediate and long-term social sector housing outcomes of domestic abuse victims. However, various stakeholders have pointed out that the 3-month maximum DAPO timescale may be too short to ensure eviction proceedings can be completed. Furthermore, Police Scotland has stressed that DAPNs and DAPOs, which require the perpetrator to leave the home they share with the victim, should only be used where absolutely necessary and not routinely, and that how often and exactly when and where they will be used needs to be clear. Additionally, there are some concerns that in seeking to provide this improved protection for victims, the rights of suspected perpetrators may be infringed in terms of the European Convention of Human Rights. Consequently, while the Bill's objectives are most certainly welcome to ensure adequate protection for victims from their abusers, the concerns of key stakeholders which have been raised must be addressed. For example, Section 4 provides only a senior police officer is able to issue a DAPM. Police Scotland and the Law Society have questioned how this would work in practice. As senior officers are generally desk-bound and rarely at the scene of a domestic abuse incident. Also, the senior officer must have reasonable grounds to believe there has been abusive behaviour and to issue a DAPN. The Law Society questioned what reasonable grounds means in practice. Would it mean, would a neighbour's anonymous tip-off be sufficient even if the victim disputes the claim? Any DAPN test must clearly then be carefully considered. Section 7 and 16 provide it's an offence to breach a DAPN and DAPO respectively without reasonable excuse. No explanation or examples are given as to what would constitute a reasonable excuse for breaching a DAPO or a DAPN. But breach offences can result in not only a fine, but a prison sentence, and clarification here is therefore essential. Police Scotland has legitimate concerns that officers could be held liable for failing to issue a DAPN when required or wrongly issuing one, and it's been stressed the need for further training and guidance for police officers, and that police are adequately resourced to, as Women's Aid state, ensure the effective implementation of the bill. Deputy Presiding Officer, the Scottish Conservatives know just how important this bill is to victims of domestic abuse and wholeheartedly support the general principles, but consider it will require considerable revision. The significant concerns about how some provisions will work in practice cannot be left to an implementation bog to resolve and must be addressed at stages 2 and 3 in order to ensure the bill protects domestic abuse victims to best effect and that police officers are sufficiently resourced and trained to properly discharge the extensive new powers this legislation gives them. Thank you.
Thank you very much. And I now call on Hamza Yousaf to wind up the debate on behalf of the Government. Hamza Yousaf.
Thank you, Presiding Officer. Can I welcome what has been a very good debate, welcome the contributions from right across the Chamber, and welcome the fact that we've heard from each and every member that they will be supporting the bill, the general principles of the bill, during this stage 1 debate and that decision time today, for which I am grateful. I'm also grateful for their feedback. I know that in the midst of a global pandemic, perhaps it is difficult to have the usual conversations we would around a bill. The process has undoubtedly been truncated, but I do appreciate the fact that we have a very comprehensive stage 1 report, and I'd like to thank the Justice Committee once again for that report, and indeed the clerking team for the effort that they have put in, as well as all of those who gave evidence to the Justice Committee. I want to try to spend my time, Presiding Officer, just addressing some of the areas and issues of concern raised by members. I've taken a fair number of notes on some of those concerns. A number of members, Rhoda Grant, John Finney, Rachel Hamilton, Liam Kerr, all raised issues around the interaction of a DAPN or DAPO with other court orders, particularly relating to children of the person against whom the order is made. So to be clear from the offset, it is a criminal offence, as the bill highlights. It's a criminal offence to breach any terms of a DAPN or DAPO without reasonable excuse. The fact that a contact or residence order was in effect would not change this fact. It would not prevent a DAPN or DAPO from taking effect. I know the committee's view, and a number of members have articulated it, that provisions should be made on the face of the bill, making this absolutely clear. And I will give careful consideration to that recommendation. However, I would need to ensure that such an amendment wouldn't risk calling into question provisions in other legislation where this issue is not explicit in the face of the legislation. As ever, I would like to just ensure that there aren't any unintended adverse consequences by such an amendment. I should also say that it is not unusual for courts to take into account child contact orders when perhaps imposing other orders such as an exclusion order or indeed a non-harassment order, for example. In terms of interaction with any other requirements for a person against whom a DAPO or DAPN is made to remain at a particular address, again, a number of members referenced the issue of home detention. I think Laura Grant mentioned it in her opening speech in particular. And I did address this issue during my evidence session at committee, and the answer, in a sense, I think is quite straightforward. If the police consider the imposition of a DAPN as being necessary to protect a person at risk of domestic abuse, or indeed the court considers a DAPO as necessary for the same reason, then they may well impose a DAPN or DAPO. This may affect existing conditions a person is subject to, i.e., to stay at a particular address as part of their release on home detention curfew. Where a DAPN or DAPO is imposed, it will then be for Police Scotland to ensure that that information about this new development is passed on to the relevant agency for HDC. That would be SPS, Scottish Prison Service. For release on licence, that would be a local authority supervising officer and Scottish ministers. So effective operational engagement will clearly be needed, and it will essentially be for those authorities, the SPS, or indeed for the local authority supervising officer, to make a determination that whether or not that individual can remain on HDC or within their licensing conditions without a recall, or indeed whether the circumstances of the imposition of a DAPN or DAPO merit recall back into custody. However, I will ensure that this is an issue that is discussed, government-chaired implementation board, but I do not think it is as complex as perhaps some members.
I'm a teacher, Mom.
I will continue. I also noted a number of members wish to make the point of extending powers or potentially extending powers to other organisations to make a DAPO, or to apply, I should say, to the courts to make a DAPO. In particular, local authorities and registered social landlords, they will often have to respond to domestic abuse cases, and there could be cases where it would be helpful for them to apply for a DAPO on behalf of a person at risk, rather than having to approach the police. I know the Justice Committee have indicated in their report this is something which could be considered at some point in the future, and I agree, if the bill is passed by Parliament, it's something which could be considered in light of experience of the operation of the scheme. Going to some points that were raised by a number of members. John Finney raised the point, and Polly McNeill also raised the point, and Rhoda Grant raised the issue of what of the suspected perpetrator and whether more than advice and assistance should be provided to them as per the recommendations of the bill. And I have listened carefully to views on this point. I do remain of the view that the provision in this regard is appropriate. My concern would be that if we were to impose a further duty on social landlords, then they may be reluctant to use the powers that this bill provides. And of course, existing homelessness legislation does place a duty upon local authorities to provide support and accommodation to those presenting as homeless. John Finney made the point that he was concerned that police were effectively being given the powers of a court of law. I simply have a fundamental disagreement with him, and happy to take that disagreement and conversation with him offline. It is because we are so concerned about the ECHR implications of any DAPN, that there is such a narrow and short time window, a time scale by which a police officer has to then apply to the court on the next court day for a DAPO, because precisely for the reason that we believe judicial oversight is required for such significant powers, and that time scale is so short. But again, I'd be happy to take those issues up with John Finney. Rachel Hamilton asked about DAPNs, how would they be issued in practice? And again, I'd refer her to similar provisions in England and Wales, where the majority of protective orders are issued at a police station. Although I take the point, of course, that in some cases, an individual would not be compelled to go to a police station, may refuse to go to a police station, and therefore, of course, police could then return to an address and issue an individual with a DAPN. If that individual was not at their address, then of course that is not an uncommon situation for Police Scotland, and they would use their powers necessary to track down that individual. Rachel Hamilton also asked about financial abuse. That does come under the definition of domestic abuse. However, if and ex-partners, I should say, are also covered by the bill. However, if of course the individuals are living separately, that may be an issue, and therefore it may be that this particular protective order is not the correct remedy to that situation. So all in all, Presiding Officer, this has been a good debate, a helpful debate in terms of understanding from members where their main concerns are. Look forward to working with those right across the chamber to address a number of these issues. But I have no doubt whatsoever that regardless of the concerns that individual members and their parties have, that we are all absolutely united in ensuring that police have every tool possible to help tackle the scourge of domestic abuse, which is a cancer in our society, and one, I'm afraid, that has been of great concern, particularly during this lockdown period. So I commit to work with members right across the chamber, to work with operational partners, to work with victim support organisations. I'm happy to move the motion in my name, Presiding Officer, and look forward, as I say, to further engagement on this matter.
Thank you very much, Cabinet Secretary. That concludes the debate on the Domestic Abuse Protection Scotland Bill. It is now time to move on to the next item of business. The next item of business is consideration of motion 23959 in the name of Kate Forbes on a financial resolution for the Domestic Abuse Protection Scotland Bill. And I now call on Kate Forbes to move. I now call on Kate Forbes to move that motion. Moved. Thank you very much, Minister. The question on this motion will be put at decision time. The next item of business is consideration of business motion 23997 in the name of Graham Day on behalf of the Parliamentary Bureau on a Stage 2 timetable for a bill. Any member who wishes to speak against the motion should press the request to speak button now, and I call on Graham Day to move the motion. Minister.
Moved, Presiding Officer.
Thank you very much. No member has asked to speak against the motion. Therefore, the question is that motion 23997 be agreed. Are we all agreed? The motion is therefore agreed. The next item of business is consideration of Parliamentary Bureau motion 23972 on approval of an SSI. And I ask Graham Day, on behalf of the Parliamentary Bureau, to move and speak to the motion. Minister.
Thank you, Presiding Officer, and I speak in relation to the protocol between the Government and the Parliament around COVID-related SSIs. This particular SSI modifies some of the restrictions on international travel by removing Namibia, the United States, Virgin Islands and Uruguay from the list of exempt countries in the international travel regulations. They also amend the review period for the international travel regs and the information regulations to 28 days. They further amend the exemptions for essential government business in the international travel regulations and add exemptions for TV production, journalism and the performing arts to the same. These regulations came into force on the 19th of December 2020 and I move.
This motion will be put at decision time. I am minded to accept a motion without notice to bring forward the decision time to now, and I invite Graham Day, Minister for Parliamentary Business and Veterans, to move that motion. Graham Day.
Move, Presiding Officer.
Thank you very much. The question is that decision time be brought forward to now. Are we all agreed? Yes. We are agreed. We now move to decision time. There are 3 questions to be put as a result of today's business. The first question is that motion 23983 in the name of Hamza Youssef on the Domestic Abuse Protection Scotland Bill at stage 1 be agreed. Are we all agreed? Yes. The motion is therefore agreed. We move. The second question is that motion 23959 in the name of Kate Forbes on the Domestic Abuse Protection Scotland Bill financial resolution be agreed. Are we all agreed? Yes. We are agreed. And the final question is that motion 23972 in the name of Graham Day on approval of an SSI be agreed. Are we all agreed? Yes. We are agreed. That concludes decision time, and I now close this meeting.